So the interesting thing is the way
Thank you.
This afternoon I shall address the State's oral argument on the Thales stay application, which, as the Court knows, is dealt with in our heads of argument at page 215, paragraphs 508 and following. I shall deal with the following four matters. The first is the delay and the responsibility for it. Secondly, the nature and seriousness of the offence. Thirdly, the strength of the case against Thales. and lastly, the trial prejudice claim by Thales. There will be some overlap between what I'm submitting to the court this afternoon in relation to Thales and what my learned friend Mr. Trengove has submitted to the court this morning in respect of Mr. Zuma. I shall try and keep that to a minimum, but in order to present a coherent argument, I will have to occasionally refer to events and sometimes to legal principles which he has already made submissions to the court on. Starting then with the delay and the responsibility for it. What I'd like to do at the outset is just briefly to set the scene with reference to the sequence of events, specifically those relevant to the submissions that I'm going to make in connection with the responsibility for the delay. I ask the court to bear with me for a minute or two as I go through events with which the court will be well familiar, but I do so to contextualize what I'm about to say. Firstly, we know from what was said this morning that on the 19th of April 2004, following an approach by Thales, Mr. Nuka agreed to withdraw against Tint Pty Limited, which at that stage was accused number 11 in the Sheikh matter, if Mr. Tettard provided an affidavit saying that he was the author of the encrypted fax. The agreement was reached at a meeting which was attended by, amongst others, Ms. Guerrier of Thales, Mr. Naidu SC, and Mr. Dryman, legal representatives of Thales. The next day, Mr. Tettard made that affidavit, and on the 4th of May 2004, Mr. Nuka consequently wrote to Mr. Naidu SC saying the state would withdraw the charges against Tint Pty Limited on the date of the next appearance, which was the trial date scheduled for the 11th of October. That was duly done on the 11th of October. The next significant event is on 20 June 2005, when Mr. Picoli announced his decision to prosecute Mr. Zuma. As we know, this followed the conviction and sentencing of Mr. Sheikh and Nkobi earlier that month at the conclusion of the Sheikh trial. A couple of months later, on the 18th of August 2005, the DSO conducted an extensive search and seizure operation, including at Mr. Zuma's premises, at the office of his attorney, Mr. Hully, at Thales' South African offices, and the home of its local CEO, Mr. Moino. On the 10th of October 2005, Mr. Zuma and Mr. Hully launched an attack on the search warrants in the Durban High Court. On the 4th of November 2005, Thales, in other words, the present second accused, which was then named Tint Holding Southern Africa Pty Limited, and its co-subsidiary, Tint Pty Limited, and I shall refer to them as Thales and Tint respectively, they were summoned to appear as Mr. Zuma's co-accused in a trial scheduled to start on the 31st of July 2006 in this court. On the 5th of January 2006, Thales and Tint, together with the Moinos, launched an attack on the search warrants in the Pretoria High Court. As the court knows, the state abandoned the searches insofar as the Moinos' home is concerned, and that matter proceeded solely in respect of the Thales business premises. The following month, on the 15th of February 2006, the Durban High Court upheld Mr. Zuma's and Mr. Hully's attack on the search warrants. The state appealed. On the 4th of July 2006, the Pretoria High Court dismissed the search warrants attacks by Thales and Tint. They in turn appealed. On the 19th of July 2006, due to the search warrant litigation, the state applied for the postponement of the criminal trial to a date in the first half of 2007. On the appointed trial date, 31 July 2006, Mr. Zuma, Thales and Tint, firstly, opposed the state's postponement application, and secondly, counter-applied for permanent stays of their prosecution. On the 20th of September 2006, Justice Msimang refused the state's postponement application and struck the matter from the roll, thereby bringing that prosecution to an end. In December 2006, Thales and Tint joined Mr. Zuma in opposing an application by the state for the issuing by a judge of a letter of request to the Mauritius authorities for the originals of all documents seized during searches there in October 2001. On the 2nd of April 2007, this court issued the letter of request, and Mr. Zuma, Thales and Tint appealed. On the 8th of November 2007, in all of the appeals that I have just mentioned, in other words, appeals by the state, Mr. Zuma, Thales and Tint, regarding the search warrants and the letter of request, the SCA upheld the search warrants and the issuing of the letter of request. On the 28th of December 2007, Mr. Zuma, Thales and Tint were recharged. On the 23rd of June 2008, Mr. Zuma brought an application in this court for the review and setting aside of the decision to recharge him, alleging that he should have been given a prior hearing. On the 31st of July 2008, the Constitutional Court dismissed the final appeals by Mr. Zuma, Thales and Tint regarding the search warrant and the letter of request. On the 12th of September 2008, Justice Nicholson upheld Mr. Zuma's no prior hearing application for judicial review. On the 12th of January 2009, however, the SCA reversed Nicholson J's decision. In February and March 2009, Mr. Zuma made representations that the charges against him be withdrawn. These included allegations of political meddling in the timing of the service of the indictment on him in December 2007. On the 6th of April that year, 2009, the acting NDP, Mr. Mshe, accepted Mr. Zuma's representations. He decided to withdraw the charges against Mr. Zuma. And importantly for this afternoon's proceedings, he also decided to withdraw against Thales and Tint. The reasons for that decision, that is the one to withdraw against Thales and Tint, are set out by Mr. Downer in the Zuma record, volume 10, page 2863, paragraph 380, which in turn is based on a contemporaneous memo, Annexure NPA 85. It is in volume 14, page 4157, paragraph 2.2. The following day, 7 April 2009, the state formally withdrew the charges against Mr. Zuma, Thales and Tint. And as the court knows, on the same day, the Democratic Alliance applied for judicial review of Mr. Mshe's decision to withdraw the charges against Mr. Zuma, the spy tapes matter. It did not challenge Mr. Mshe's decision to withdraw the charges against Thales and Tint. Eventually, on the 13th of October 2007, the SCA upheld a decision of the full bench in the Pretoria High Court reviewing and setting aside Mr. Mshe's decision to withdraw the charges against Mr. Zuma. As a result, the criminal proceedings against Mr. Zuma, but not those against Thales and Tint, were reinstated with effect from that day. On the 16th of March 2018, Mr. Abrams, the then NDPP, announced his decision not to accede to further representations by Mr. Zuma, that the prosecution be stopped. He also announced that Thales and Tint would be recharged and tried together with Mr. Zuma. Several weeks later, on the 6th of April 2018, Mr. Zuma and Thales, but not Tint, appeared in this court. Tint did not appear because sometime between April 2009 and March 2018 it had been deregistered. Since then, the matter has been postponed several times to allow Thales to make representations, which were refused on the 25th of July 2018, and to allow Mr. Zuma and Thales to bring the present proceedings. That then is the time span. We submit in our heads of argument at page 215 in paragraph 509 that Thales is to blame for the delay from 2004 onwards. In summary, our reasons for that submission are the following. From its inception, the state's case has been that when Mr. Tetard composed and caused the encrypted fax to be sent, he was a director of both Tint and Thales. Consequently, those companies, the state alleges, are criminally liable for his actions in terms of Section 332(1) of the Criminal Procedure Act. That is stated by Mr. Downer at page 135 of the Thales record in paragraph 9. I interject with a word about Thales' replying affidavit. The court will have noticed that it is not in the conventional form. It does not deal ad seriatim with the allegations of the state. One of the allegations which Thales does not dispute, with respect to Thales, it's rather argumentative replying affidavit, is the factual allegation in Mr. Downer's answering affidavit at paragraph 10, page 135, that what the state was trying to achieve with the prosecution of Tint Pty Limited in 2003 together and 2004, that is the prosecution of that company together with Mr. Sheikh, was the conviction of the Thales Group through one of the two local Thales Group subsidiaries that were involved. The court will recall that Mr. Sheikh was a director of that company, and consequently there would not be procedural difficulties with it being charged together with the companies in his Inkobi group and himself personally. As Mr. Downer explains in paragraph 12 of his affidavit at page 137, were it not for Thales' representations in 2004 and the ensuing agreement with the state in April 2004, the trial of Tint would have started on the 11th of October 2004 as part of the Sheikh trial, and it would have been either convicted or acquitted in that trial.
I also remember vividly reading when Thales made submissions to us in their written heads, that if we look at the dates, yes, there was the first affidavit, but the second affidavit was also shortly thereafter, which was a long period before we got to the October trial of Mr. Sheikh.
Yes.
And then there's just this take, well, Thales is to be blamed for this delay. But is that in reality, because I've asked the same question to Mr. Trengrove,
yes,
regarding the fact the state knew that there were two contradicting statements, both made under oath. If there's something of an real criminal intent, that in itself
yes,
should have urged the state to have then proceeded with the matter.
Yes.
But it seems like Mr. Nuka honored and his word to withdraw the matter against Thales, which was Thompson CF at that stage,
yes.
And he didn't want to go back on that, and practical reasons. Now,
yes,
surely if one wants to say, and this is where the earlier argument was made that, that there is joint responsibility, surely there, the blameworthiness can't be placed directly just in front of the door of Thales. It must be also placed in front of the National Prosecuting Authority, because what reason was there to honor something where someone is clearly dishonest, to use the words of Mr. Trengrove? and has showed no integrity of honouring any deals.
I have two responses that I wish to make to that, milady. The first is that for purposes of the submissions that I'm making this afternoon, I make nothing of Thales's deceit during 2004. The second is what we know as a matter of fact, and this is stated in Mr. Nguka's affidavit, and it is not disputed by the other side, is that the reason Mr. Nguka decided to go ahead is, firstly, he's a man of his word. He decided to honour the agreement. And secondly, there were practical reasons which by that late stage, when they realised this company was negotiating in bad faith, for leaving Thales out of it. Because if they'd been brought back in, amongst other things, there would have been a delay. This is explained in his affidavit, the reason being that they would have needed time to prepare. So my point is simply this. Yes, there was a speed wobble for purposes of my submission in mid-2004 as far as this is concerned. But there are two important facts. One, Thales approached the state saying, we are an accused. Please don't prosecute us. They offered a deal, they reached an agreement, and on that basis, Mr. Nguka said in May, I will ensure that the charges against you are withdrawn. The second important fact is that the state made good on that agreement. It had good grounds for being dissatisfied with Thales, but it made good on it. And in this connection, I wish to make two consequent points. The first is that were it not for the representations, for the discussions and the agreement that was reached, Thales would have been tried together with Mr. Sheikh, and either way, in that trial, the dispute between the state and the Thales group would have been determined. And we therefore submit on the authority of Zana's case in paragraph 15, to which I shall take the court in a moment, that it does not lie in Thales's mouth to try that it was not tried sooner.
But you see, the same proposition can be said about NPA. It doesn't, the fact that Mr. Nguka is no longer there doesn't mean that the NPA must dishonour that undertaking that he made. You see, that's a difficulty.
With respect,
I thought you were on a much better ground when it was argued earlier on that there were further charges which were added pursuant to a further investigation. Yeah. This argument that you're advancing now, I don't think it will assist you.
May I conclude this argument? I will be dealing with 2006 in a moment. What I'm submitting to the court now is that this case is comparable to Zana's case. In Zana's case, a person was charged with murder in a workplace. And the accused made representations to the prosecuting authority, to the Attorney General. The representations succeeded. 10 years later, the same person was investigated for another offence. The investigating officer came across this earlier case and decided that it warranted a second look. And 10 years later, the prosecuting authority decided to reinstitute the charges. And Justice Meyer, then an acting judge of appeal, whose decision is binding on this court, the Ratio Dakidendi, said the following, and my submission is that the two cases are indistinguishable on the material facts, being the making of representations, please withdraw against me, the acceptance of those representations, and the consequent non-trial of the person subsequently complaining of an unreasonable delay many years later. What she said was the following: but for the representations made on behalf of the appellant to the Attorney General, which are peculiarly within the appellant's knowledge and details of which he chose not to disclose. The trial would have commenced on 26 January 1994. It is clear that the appellant had no interest at all in having a trial, and it hardly lies in his mouth in the circumstances to blame the police for failing to properly investigate the matter in the first instance, which is...
This is the problem I have, and I'm sorry to keep on repeating myself. If your argument is that you had to, once Zuma was out of the NPA, because those are factual issues, that he was there at the time when the undertaking was made. Thales, said they were going to cooperate. So unfortunately, they did not cooperate. And despite that, you must remember that this undertaking was made sometime in May. And despite that, in October of the same year, you decided to withdraw charges against it.
Indeed.
You see, the difficulty that you have, if your proposition is based on dishonesty of the second applicant, I don't think it's going to help you. You see, that's a problem I have, because that dishonesty was displayed before the charges were withdrawn in the Sheikh prosecution. You understand?
I understand that. And I'm not relying on the dishonesty at all. I rely on the following simple facts.
Let me just put it slightly different.
Yes.
If you're going to rely that they cannot be trusted, let me not use the word dishonest, they cannot be trusted because they couldn't keep to their word, then you will have a problem. Because as far as the papers, as I understood the papers, the main reason advanced as to why you decided to recharge the second applicant is because of the investigations that were conducted later on, which actually what that investigations revealed, and pursuant to that, you decided to charge the second applicant.
I agree with everything that your lordship says. I am making.
So what I'm trying to, for the sake of progress, what I'm trying to say, to indicate to you is that the reliance on the first proposition, nothing turns on it. You see, that's what I'm trying to say to you.
My lord, what I'm submitting to you, and I won't detain you much longer on this point, is essentially the following. Mr. Nuka explains in paragraph 83 of his affidavit at page 672 of the record why he carried on. He says that, firstly, there was the fact that he'd agreed to withdraw. And then he goes on to deal with the pragmatic reasons. But what you have is his version. And I'm not disavowing his version at all. His version is, one of the reasons I decided to withdraw, nevertheless, despite what had happened in the meantime, was I had agreed to do so.
But that did not necessarily mean that the NPA must change the tag and say that because Mr. Nuga is no longer there, we're turning our back to that undertaking and we're recharging.
I'm terribly sorry, but I'm not doing that at all. On the contrary, I'm saying that Mr. Nuka made good on the undertaking. And the thing is that the charges were withdrawn because Mr. Nuka honored an agreement that was reached in April 2004 and confirmed in May 2004. And the submission is a very narrow one. On that basis, this case is indistinguishable from Zana. In Zana's case, there was going to be a trial starting on the 26th of January 1994, but there wasn't because the Attorney General accepted representations and withdrew. And what the SCA held in those circumstances, and if you would just let me finish the submission, is the following, is that it doesn't lie in the accused's mouth to blame the police for not continuing the investigation or to argue, as his counsel sought to do, that the respondent is hiding behind a wrong or ill-considered decision to withdraw the charge. A decision which on his own version was based solely on his entreaties.
But before you can even go further, you must bear in mind that in this instance,
Yes.
when Mr. Tate had changed his mind, he decided to file or to give you the second affidavit. The trial was still going to come in October of the same year. So the NPA had time to reflect and consider his filing of the second statement.
Yes.
And as a result, you reflected, and your reflection, upon reflecting, you came to the conclusion that, look, it is best to withdraw charges. That's where we have a problem. So what we're saying, you can't then go back and say, look, we must rely on that.
I must say, I really struggle to follow it because
I think what my brother is saying is that don't rely much more about the trustworthiness or otherwise of Thales because they've already shown you before, but rely more on the other pragmatic reasons.
I understand that, but what I'm submitting to the court is that Mr. Nguka in his affidavit, and I stand by his affidavit, gives both reasons, and they are not disputed by the other side. And the court consequently cannot ignore the first reason, which is that his words were, aside from the fact that I'd agreed to do so, there were pragmatic factors. Two reasons.
But I don't think we are ignoring that, Mr. Breitenbach. I think the real issue here is when the NPA stands here today and argue to us that Thales is to be blamed for the delay since 2004. That's a submission you were making, and then you were taking us to the fact that there were these representations, and then these representations led to the fact that the matter was withdrawn then in October. Now it's on that basis that we're really trying to understand your submission, and it ties up with what Mr. Trenkov earlier is about this responsibility, who's to causing this delay. Because really, strictly speaking, the delay has been caused by the NPA. The NPA hasn't knowingly, and just for one moment, you have two affidavits, clear perjury. You honor, and yes, you honor that agreement. But that reflection, as my brother referred to, there were months to do that. And despite all of that reflection, you decide to withdraw. If it is the matter that the reason why the withdrawal was because there were further investigations and other charges, that was the stronger argument that we understood on the papers to be made.
But that was also made by Mr. Trengo.
Yes.
When he said that they were afraid that the delay, the charging tells, would cause the delay in the Shaik trial because issues of misjoinder or non-joinder could be raised.
Yes, it's not an argument, my lady.
Yes.
It is what Mr. Nguka says in his affidavit.
Yes.
And I'm making a very modest submission. He gives two reasons for going through with it. The pragmatic reasons are there for sure. I do not dispute that. I'm bound by that, just as the court is bound by it.
That's fine. We can
The
move
court
on.
has it. So the submission then is that the case is indistinguishable from Zana. Essentially, Thales got what they asked for, which was the withdrawal of the charges in 2004, and on the strength of Zana's case, it lies ill in their mouth to complain that they should have been charged and tried that it was wrong to charge and try them later. The next submission, which is made in the alternative to the submission that I just made, and it's one which operates in any event, because it's not logically inconsistent with the one that I've just made. It's dealt with in our heads of argument at page 217 at paragraph 514. And it is a submission that Thales, together with Mr. Zuma, are to blame for the delay from 2006 onwards. Now, this is a matter which is was canvassed with my learned friend this morning to some degree, and also with my learned friend, Mr. Katz, particularly when he made submissions on Tuesday. So it's from 2006 onwards. Now, the submission here, firstly, is that had Mr. Zuma and the Thales companies not launched the proceedings to set aside the searches of their premises in August 2005 and persisted with those proceedings until July 2008, the following three important facts would either have happened or would not have happened. The first is the state would have been ready to proceed with the trial on the 31st of July 2006. The second is the prosecution would not have been struck from the roll on 20 September 2006 because the state wasn't then ready. And the third is that Thales and its co-subsidiary Tint would have been tried together with Mr. Zuma in that trial and either acquitted or convicted in the trial. Now let me say immediately that this doesn't mean that Mr. Zuma and Thales companies had to give up the chance to challenge the search warrants and the ensuing searches. What we are submitting is they had another equally effective remedy, which, had they elected to use it, would not have delayed the start of the trial. Instead of launching and persisting with pre-trial civil litigation to challenge the search warrants, they could have proceeded to trial and raised their objections to the validity of the warrants when the state sought to adduce the evidence obtained during the searches. And it is a very important point in this matter. As far as Mr. Zuma and the Thales companies are concerned, they were accused, unlike third parties whose premises are searched and who can only vindicate their infringement of their right to privacy if they believe it's unjustified by launching the kind of civil proceedings that we see here. Accused persons have the option to let the trial begin and object to the admission of the evidence in the trial.
But that option doesn't include vindicating their right before the matter goes to trial. They can do also do that. It's one of the options that they used.
I understand
and it
that.
was within their right to use it.
They had an election. And the point for present purposes is that if they had elected the other way,
Yes.
the trial would probably have been completed one way or the other during 2007. So they must live with the consequence of that election. And as my learned friend Mr. Tringove pointed out, that consequence was delay. And it is that which the Constitutional Court in paragraph 65 of the search warrant litigation pointed out. The type, my lords, my lord and my ladies, there is one remark made this morning which I most respectfully submit needs to be qualified. When one is dealing with an accused person, there is not an equivalence from the court's perspective of going the one route, the pre-trial civil proceedings route, and the other, which is raising the objections in the trial. The Constitutional Court has made it plain that pre-trial civil proceedings by accused persons which will have the effect of delaying are generally undesirable. So the route that they chose is the generally undesirable route for the very reason that Chief Justice Langa identified there, delay.
Is in the circumstances of both Mr. Zuma and Thales, is the delay not attributable to both? Because whilst they could have objected on those searches during the trial, but the state also could have exercised an option of not to appeal on the first decisions of the court. So is there anybody to blame per se, or both, all the parties should take blame because you were in it, all of you?
No, we were not in it. We were sued by them in generally undesirable pre-trial civil litigation, which, as things turned out, was ill-founded and wasted 3 years.
But if we look at the search warrant challenges, Mr. Breitenbach, then
Yes.
it wasn't only a people accused that were accused before the court that challenged the search warrants. So you see that election was an election by various people, and not all of them qualify as being labeled as accused persons before the court.
I agree with that. The other, you're quite correct, my lady. There was Ms. Mohammed.
Yes. Mr.
There-
Ali,
yes, Mr. Halley was with Mr.
Yeah.
Zuma in the same
Yes.
case. And then there was a Mr. Kogel and
yeah.
K Nominees, his company. Mr. Sheikh too.
Yes.
The court will see from the chronology that only one of those other cases, Mr. Halley's went together with Mr. Zuma, proceeded to the stage of judgment. They were severely disruptive because the state suddenly had to deal with all of these things. But they were only, well, one of them went to the stage of judgment. That was the Muhammad matter. It was heard together with the state's appeal in the Zuma Halley matter, and with Thales' and Tint's appeal in their own matter in late 2007 and decided in November of that year. Obviously, here, the most important searches were the searches of the premises of the two accused. And the stoutest fight was put up in connection with them and with the box of materials that Mr. Reeves Parsi, Mr. Sheikh's former attorney, gave to Mr. Halley, and which was taken unopened during that search. May I mention one other thing which relates to a remark from the bench this morning. In the Constitutional Court case, which at the culmination of these proceedings, the Constitutional Court made it clear that the searches and seizures operations that the state undertook were legitimate and perfectly proper. Not just lawful, but were the right thing to do from an investigatory point of view. But the ultimate point that I'm making is really this one. These accused...
But the only way that those who were affected could find out was to taking that dispute to court. That's the only way. And the court had to make a pronouncement on it.
My Lord, if you were appointed as the judge in a criminal trial in which the state was relying on evidence obtained during a search and seizure operation, and the accused contended that the warrant was overbroad...
But you still have a trial within a trial to mention on the
It reaches
issue.
the same delay.
Yes.
But-
same
but no delay.
Same outcome.
No, but the trial starts, my Lord.
Yes.
The
And in the
trial
trial within the
starts.
trial, you continue with, I don't agree with him. Because the trial starts and it proceeds until finalized, and then you take it on appeal. And you make your ruling, you don't even give reasons to.
My lady, I can do no more than agree with you. They had an election. They chose the election which had the inevitable effect of delaying the commencement of the trial. We are now grappling with the question, who's to blame?
But you're criticizing the
One side.
one side, yes, you not because they have a right. They had a right to do that. They were affected. They had a right to have their dispute determined by a court.
At the risk of
Especially because you, as my sister mentioned earlier on, you had people who were not even accused in the matter. So there were people who were not involved at all in the criminal trial itself or criminal matter itself.
No, that is certainly so.
Yes.
But as I've pointed out to you, only one of those cases proceeded to the stage of judgment, which was one of the other cases, which was Ms. Muhammad's case, and that was dealt with by the end of 2007. The real dispute, the real fight in that matter was between the accused and the state. And my simple points are these. The state was acting within its rights and quite properly to undertake the search and seizure operations.
No, we don't have a problem with that. There is also a finding to that effect.
That is correct.
I think we'll deal with it. I think we will consider the matter.
The second
see
point-
how far it can take.
Thank you, my Lord. The second point that I just wish to emphasize is that the election that was made by the accused, and I'm focusing specifically on them, was to go for what the courts regard as generally undesirable way of raising this problem. The desirable way from a administration of justice point of view, because of the importance of trials starting without undue delay, was to raise it within the trial. There is not an equivalence in that election. They chose the route which resulted in delay. But the most important fact is that whether they were entitled to do that and less desirable, more desirable, the result was delay. We submit that if they had gone the other way, in other words, had not embarked on pre-trial litigation, but had raised this in the trial, there would have been a number of important consequences. Because the matter wouldn't have been struck from the roll, there would have been no need for Mr. Zuma and the Thales companies to be re-indicted following the SCA decisions at the end of November 2007.
Thanks.
Had they gone the other route, there would have been no need for Mr. Zuma and the Thales companies to be re-indicted, because the matter wouldn't have been struck from the roll. The controversy about the timing of their re-indictment arising from the actions of Mr. McCarthy would not have arisen. The ill-fated decision of Mr. Mshe to terminate the prosecution on the 6th of April 2009 because of that controversy would not have been taken. The withdrawal of the charges against Mr. Zuma and Thales on the following day wouldn't have occurred, and there would have been no need for the drawn-out DA litigation. These are matters of fact. Had they gone to trial, in other words, this case would have been wrapped up one way or the other, probably during 2007. And things went the way they did as a matter of fact, the sequence of events that I've just described, because of the election that they made. It follows that Thales and Mr. Zuma in our submission are the ones responsible for the delay from 2006 onwards. If, however, the court does not accept the submissions that I have just made, then we would ask the court to consider the following. Firstly, at worst for the state, Thales and the state are jointly responsible for the delay occasioned by Thales' co-subsidiary Tint not being tried together with Mr. Sheikh. In other words, it was an interactive process in 2004. And we therefore submit that that period, as far as Thales is concerned, from 2004 until the end of the Sheikh trial in mid-2005 is a neutral factor, as between the state and Thales. I've already made my submissions about why Thales and Mr. Zuma are jointly to blame for the period specifically which is covered by the search warrant litigation. That runs from late 2005 to mid-2008. My learned friend, Mr. Trengove, has submitted, and I submit again, that Mr. Zuma, not the state, is to blame for the delay occasioned by the Audi or no prior hearing litigation, which started in the middle of 2008 and ended in January 2009. Mr. Zuma, not the state, is to blame for the delay which was occasioned by him making the representations and them having to be considered. It was the state's duty to consider those representations. That is between February and early April 2009. And then the period which is potentially the most troublesome for the state as far as Thales is concerned, the period from April 2005 onwards. I listened carefully to the debate 2009 onwards. I listened carefully to the debate between my learned friend, Mr. Trengove, and the court this morning about that, and I don't want to traverse the ground unduly. What we submit for the court's consideration in this connection is that Mr. Zuma and the state are jointly responsible for Mr. Mshe's decision and for the time taken up thereafter with the DA litigation. My learned friend, Mr. Trengove, explained far more eloquently than I can why one must separate that into the two. Mr. Mshe's decision, which was effectively on ZANA principles, giving someone making representations what they wanted, as deficient as the decision turned out to be. And then obviously they stood shoulder to shoulder most of the time in defending my client and Mr. Zuma, the DA's litigation. There was one appeal to the Supreme Court of Appeal. It was in relation to the second interlocutory concerning the record, where Mr. Zuma went on his own. But for the rest, my client and Mr. Zuma stood shoulder to shoulder there. And in this regard, I offer the following for this court's consideration. Even if the state had not opposed the DA's application, based on how Mr. Zuma conducted his defense and generally how he has approached defending the matter thus far, there is no reason to think that if the state had not opposed the DA's application, Mr. Zuma would have followed suit. As my learned friend Mr. Trengove put it, the case could have been over in 3 or 4 months as an unopposed review. Had the state not opposed, there's no reason to think that Mr. Zuma wouldn't have opposed. On the contrary, as we have submitted, his Stalingrad defense strategy indicates that he would have persisted with the opposition. And lastly, as regards this period, and this goes to a matter I'll touch on later in my submissions, which is trial-related prejudice, we would emphasize that the 20-year prescription period set out in Section 18 of the Criminal Procedure Act for the offences with which Thales had been charged prior to the withdrawal did not expire during the spy tapes litigation. And as Mr. Dana explains in his affidavit at page 153 in paragraph 48, the Thales Group must have known that a possible outcome of the proceedings by the DA was that Mr. Mshe's decision would be set aside. Yes, it was focused on Mr. Zuma alone, but they must also have known that if that happened, a possible outcome was that the status quo, including the charges against the Thales companies, would be restored. The matter was certainly not settled. And in fact, it only became settled on the 13th of October 2017, adversely to the NPA and Mr. Zuma. As far as the further periods of time after that are concerned, very briefly, we submit Mr. Zuma, not the state, is responsible for the time taken to make his representations and for them to be considered by the state. That was between October 2018 and October 2017, I apologize, and March 2018. And then the period after the charges were reinstated, there we submit, subject to a qualification, that Mr. Zuma and Thales are largely responsible for the time taken since their first appearance in April 2018. The reasons are, as the court knows, the matter was adjourned for representations by Thales and for the two of them to bring the current litigation. Having said that, we do accept that even had they not taken those steps, there would inevitably have been some delay from March 2018 because firstly they would legitimately have been entitled to time to prepare properly for the commencement of the trial, and secondly there's the systemic issue of getting dates for a trial of this magnitude on this court's roll. But that then those would be what we would regard as systemic delays for which the state cannot be blamed. That then is my dealing with the first of the factors, the Sanderson factors, the period of time and the responsibility for it. I'd like to turn then relatively briefly to the nature and seriousness of the offence, which was covered by my learned friend this morning. The first point that we make is during its oral argument, Thales' counsel conceded that the offences with which it is charged are very serious, and we submit the concession was rightly made We submit the concession was rightly made because the charges involved the alleged corruption of the second most senior member of the National Executive and related racketeering and money laundering. In this regard, we rely on Zana's case at paragraph 21, and it was dealt with by my learned friend this morning. The point is that in a case involving a serious offence, the societal demand to bring the accused to trial is much greater, and the court should be much slower to grant a permanent stay. We also, however, rely on Botma versus Else, paragraphs 62 to 66, and especially paragraph 67, where the Constitutional Court said, "Of central significance will always be the nature of the offence. The less grave the breach of the law, the less fair it will be to require the accused to bear the consequences of the delay. The more serious the offence, the greater the need for fairness to the public and the complainant by ensuring that the matter goes to trial." We submit that in this case, the following factors connected with the nature of the offence weigh heavily in favour of allowing Thales to be tried on the charges against it. The first is fairness to the public. Secondly, public confidence in the criminal justice system. Thirdly, the need to redress the harm to our society and to our constitutional order by grave crimes such as those with which Thales is charged. And I stress that that is obviously a possible outcome. But the point I'm making is that that possible outcome will be foreclosed if the prosecution is permanently stayed. Finally, in this regard, we respectfully remind the Court of the observation by the Constitutional Court in Sanderson's case at paragraph 38, that in order that a prosecution be permanently stayed is, and I quote, "a radical, both philosophically and socio-politically. Barring the prosecution before the trial begins, and consequently without any opportunity to ascertain the real effect of the delay on the outcome of the case, is far-reaching. Indeed, it prevents the prosecution from presenting society's complaint against an alleged transgressor of society's rules of conduct. That will seldom be warranted in the absence of significant prejudice to the accused." Now, before dealing with that claim by the accused in this matter, Thales, of significant prejudice, I'd like to deal briefly with a related consideration, the nature of the offence, the strength of the case against Thales. We submit that the evidence against Thales is very strong, as the findings of the Sheikh trial court, especially in relation to count 3, have shown. They are quoted in our heads of argument at page 86, paragraph 186. And the court knows that the evidential foundation of that particular charge is the handwritten draft of the encrypted fax. The evidence that is available has, save for the death of Mr. Leek, of which we learned today, not diminished in strength since then. There are, of course, various ways in which statements made by someone who has died can be admitted in evidence. I refer the court in this regard to Mr. Abrams's affidavit. I'll give the references in the Zuma record. It's volume 16, page 4568, paragraphs 24 and 25, and 4573 in paragraph 39. And in this connection, we would also point out that the only exculpatory version the state has ever received from the Thales group was its unsolicited provision of the second affidavit by Mr. Tetard, the one dated the 10th of May 2004. But as my learned friend Mr. Trengove explained this morning, the evidence in the Sheikh trial established that Mr. Tetard was lying in that affidavit about the encrypted fax. So a relevant factor then is that Thales is charged with very serious offences and that the evidence against it is very strong. This is a unique case in that respect because there has been a lengthy trial of one of the co-actors, one of the people involved. This court has the benefit not only of a detailed, with respect careful judgment by the trial court, but judgments by the Supreme Court of Appeal and even the Constitutional Court in that criminal matter. The court is therefore able to assess in a unique way the strength of the case against the accused, a way that courts often can't do when a trial is simply an indictment and the state's witness list and general statement of the offences. That then brings me to the reason why Thales says that the radical remedy of a permanent stay of prosecution is warranted in this case. And it was made clear in argument to this court on Tuesday that the only prejudice claimed by Thales is trial prejudice, forensic prejudice. Now, before dealing with the relevant facts, we submit it is useful briefly to recap the main principles which were laid down by the Constitutional Court in Botma. And the reason is that we submit that this is the leading case on trial prejudice. In this regard, first and foremost, we stress that the test is irreparable trial prejudice. More specifically, insurmountable damage to the fairness and integrity of the envisaged trial. We rely in this regard on paragraph 68 of Botma's case, in which the Constitutional Court said the following: irreparable prejudice must refer to something more than the disadvantage caused by the loss of evidence that can happen in any trial. Thus, irretrievable loss of some evidence, even if associated with delay, is not determinative of irreparable trial prejudice. Irreparability should not be equated with irretrievability. Clearly, potential witnesses who have died cannot be revived. Documents that have gone permanently astray may not be capable of recreation. Irreparability in this context must therefore relate to insurmountable damage caused not to the sources of testimony as such, but to the fairness and integrity of a possible trial. Put another way, to say that the trial has been irreparably prejudiced is to accept that there is no way in which the fairness of the trial could be sustained. That is the test that both applicants in this matter have to persuade the court of when it comes to trial prejudice. Sitting here today, before they have pleaded and before any evidence has been left, they have to persuade this court on the probabilities that there is no way, not on the probabilities, on the evidence in the application, that there's no way that the fairness of the trial can be sustained. A very high standard indeed. Secondly, in the Botma case, at paragraph 75, the Constitutional Court said that cases where the state is responsible for the loss of crucial documents in the period after the commission of the offence are qualitatively different from the irretrievable weakening of a defence that flows from loss of evidence of the kind that could happen even with short delays, but be intensified by long delays. Witnesses die, evidence disappears, and memories failed. So the Constitutional Court is phlegmatic, relatively speaking, about those consequences. And the reason is because of the very high standard which applies to stopping a prosecution before it starts, but also crucially, as we shall see from the principles to which I'm now going to refer the court, to the fact that the trial judge is well equipped, in fact, best equipped to deal with the kind of prejudice to the fair trial right of an accused that ensues from the death of witnesses, the disappearance of evidence, and the fading of memories. And we refer in this regard, again,
I've looked at the list of authorities given to us by the National Prosecuting Authority.
Yes, ma'am.
And I've noted that Naidu versus the regional magistrate, Durban, wasn't one of those, where two members of this bench have dealt with permanent stay and with Botma versus Els and with Sanderson and all of the aspects that deals. And it was a full court decision.
Yes, my lady. I'm
So
aware of the case.
just in case you think that you need to draw our specific attention to those things, a full court in this division has decided, and it's reported in 2017.
As it pleases you, my lady, I'm happy to stop with that. What I would then submit is that what it really boils down to is the following. It's that, and this is what this judgment says in paragraph 75, 81, 82, and 84, is that it is the trial court's obligation to give
That's
due
exactly what was decided in the Naidu matter.
Yes.
We dealt with that.
to the evidential deficit which an accused might have, to the paucity of evidence available, the very heavy onus which operates against the state. And consequently, we submit that what my learned friend's client has to show then is that there is no way that it can have a fair trial in the charges which are laid out in the present indictment. And therefore, on the facts, we would point out firstly the following. Thales does not allege that the conduct of the state has led to the disappearance or destruction of documents instrumental to its defence while they were in custody of the state. And indeed, as Mr. Downer has explained in his affidavit at page 143, paragraph 28, the effect of the passage of time on the availability of evidence in this particular case has been limited. And the reasons for that are, firstly, the matter was very thoroughly investigated between 2000 and 2006. Secondly, the bulk of the evidential material is documentary.
But sorry, Mr. President. The point made by Mr. Katz, and that is what is in their papers, is that even before you get to trial, he needs to consult and take instructions about those very same documents, perhaps, that you are
I
referring
will
to.
certainly deal with that. I realize it's the big point against
Yes,
that.
that is the big
The
point.
nature of the individual.
So the bulk of the evidential material is documentary. They have been preserved, and copies of most of the relevant documents were handed to Thales representatives as long ago as 2006. So why does Thales say that the passage of time has put it in a position where there is no way in which it can have a fair trial against it? In its affidavits, it refers to 4 persons with whom it wishes to consult and to call as witnesses in its defence, and says that they are no longer available to it. Now, in this regard, I would respectfully point out the following, that Thales's case has undergone a subtle but significant change from its founding papers to its replying papers. And it relates to 3 of the 4 people in question, namely Messrs. Tetard, Perrier, and de Jaumeron. In its founding papers, Thales alleged the following concerning them. I refer firstly to the founding affidavit of Ms. Gueria, page 57, paragraph 256. There she says, the 3 gentlemen in question have left the employ of the Thales group, and consequently they are not available to provide Thales legal representatives with instructions. So essentially they say because they are no longer employees of the group, they are no longer available to it to provide instructions. Secondly, as regards Mr. Tetard, at page 58 in paragraph 261, she says Mr. Tetard is not prepared to assist Thales in any way, or to return to South Africa, or to testify in South Africa or any other forum should a trial take place. And lastly, and related to and flowing from this, it's alleged in paragraph 268 at page 260 that Thales has no means of compelling these three gentlemen to provide any information or assistance to it in defending the charges brought against it. So the essential case is, because they are no longer employed by us, they are not available to us, and we have no way of compelling them to provide us with information or assistance. The power that we had over them as their employer has been lost in the meantime. That's the fact which is alleged. In the state's answering papers, there is evidence that inquiries were made by the investigating officer colonel deployed through Interpol about the whereabouts of these people. And it is recounted in Mr. Downer's affidavit at page 150, paragraph 41, and is confirmed by Mr. Deploy in his general confirmatory affidavit, which is at page 681 and following. And that was in the context, well, if they are in South Africa, you can subpoena them. If they are overseas, one can use the provisions of Section 2 of the International Cooperation in Criminal Matters Act. But so far, we've not established their whereabouts, so we don't know which of the two is available. What happens in the reply, though, is that leveraging off that evidence, namely that Mr. Deploy's inquiries through Interpol haven't turned up any information about their whereabouts, Thales now alleges that it too cannot locate them, and that it is unlikely that it will be able to do so. And that is at page 753, paragraphs 281 to 282 of the papers.
Only in reply.
But that's in its replying affidavit. Now, we submit that there is a material difference between Thales's case and its founding papers, that it had lost the means of compelling its employees to provide information or assistance to it. That was the case that the state was called upon to meet, and its new case, that it's unlikely that they can be located. And in this regard, as Justice Harams pointed out in NDPP versus Zuma, 2009-2 SA 277 SCA, at paragraph 44, and specifically in footnote 46, criticizing the judgment of Nicholson J. in the court below in that matter, and I quote, "The court was not entitled to base its judgment on something taken from an answering affidavit, unless the argument was foreshadowed in the founding affidavit, which it was not." And he cites the well-known Administrative Transvaal Theletsani case in support of that proposition. So we consequently submit that this court should disregard Thales's opportunistic attempt to shift the factual basis of this aspect of its case away from its loss of control over its employees to there being no indication of their whereabouts, by relying on the results of Colonel Deploy's inquiries through Interpol as they stood at the time when the state filed its answering papers on the 11th of March 2019. In other words, we submit that this aspect of the case must be decided on the basis that Thales has no means of compelling them to provide information and assistance to it, rather than its new allegation in reply that it's unlikely they can be located. If, however, the court were to decide that it is necessary that this aspect of the case be determined on the basis of more recent information, I must emphasize we are not applying for the admission of more information, because we submit that the proper principles should apply. My instructions are that Mr. Deploy, since the 11th of March, Colonel Deploy has received further information from Interpol about the current whereabouts of Mrs. Superior Terror, as it pleases. As it pleases you. Now, this brings me to Her Ladyship Judge Poyo Dilwati's question. Mr. Downer has dealt in his affidavit with the difficulties of compelling these people to cooperate. He says that they can be subpoenaed and ICMA provisions can be used. That's at page 150 and paragraph 41. The point which Thales made, however, in its oral submissions to this court, is that that won't help because it needs to consult with them before it can plead. And these are avenues which are available to secure their attendance at court to testify, or to testify, as it were, on commission overseas. And we see this point taken for the first time in the replying affidavit at page 755. I suspect it's paragraph 289. My note isn't all that clear. But it was emphasized particularly strongly in the oral submissions to this court. And with respect, we regard this as a startling submission. And it really amounts to this, that its problems with these three gentlemen have the result, as we understood the submission, that it doesn't know, as it stands at the moment, whether it has a defense to the charges against it in the indictment. And consequently, it will be unable to plead when called upon to do so. Now, the reasons we regard this as startling are, firstly, that in its founding affidavit, Thales asserts its innocence and substantiates that assertion. And I refer to page 22, paragraphs 78 to 80. And if the court... Page 22 would bear with me, I'd read them. Although this application doesn't concern the guilt or innocence of Thales, I am constrained to point out that it makes no sense, as is sometimes suggested, that there was room for an improper sweetening of the deal either by Thales or ADS for anyone in the procurement process. And that then is elaborated on in paragraph 79 and 80. Then at page 60, paragraphs 271 to 274, Ms. Guria says, the state alleges there was an agreement reached between Mr. Sheikh and Mr. Tetard to bribe Mr. Zuma. Insofar as Thales has been able to discern from the information available to it and from its investigations, so it has information and it's conducted investigations, no agreement of the nature described in this paragraph was ever concluded by any party acting for or on behalf of or in the interests of Thales. The state appears to rely on the so-called encrypted facts as evidence of this agreement. However, Mr. Tetard, who is the author of the encrypted facts, has stated under oath that he didn't instruct anyone to type and fax this document. According to Mr. Tetard, he had recorded in manuscript form his thoughts in a rough manner in this document and had crumpled the handwritten note and disposed of it in the waste paper basket. Mr. Tetard has stated under oath that the document which he drafted doesn't record any meeting where a bribe has been discussed, and he in fact disclaims any involvement in a plot to bribe Mr. Zuma. Then she adds, Thales has at this delayed stage, in the face of the direct evidence of Mr. Tetard as the author of the document, that there was no attempt to bribe Mr. Zuma or that Mr. Zuma had in fact been bribed, no evidence to prove or disprove this claim. And then over the page at 279, 280, a significant we submit. This is now Ms. Guria, the in-house counsel, recounting her involvement in a consultation with these three gentlemen, or in discussions with them. In 2003, I, to the best of my recollection, discussed the meeting that took place with Mr. Sheikh on 30 September 1999, at which meeting the state alleges that the agreement to pay the bribe to Mr. Zuma was made with Mr. Tetard, Mr. Peria, and Mr. Jomaron, who were present at the meeting. They denied any knowledge of the existence of any arrangement of the sort described by the state. In addition, based on Thales' investigation, so we're back to the investigation again, which included the consideration of the documents in possession and under the control of Thales, it hasn't been able to discover any evidence to support the allegation in this paragraph or to disprove the versions of Mr. Tetard, Mr. Peria, and Mr. de Jamaron. So we have a chapter and verse. It's a denial, a substantiated denial. Thales will never be in a quandary. It knows it must deny these allegations because its investigations and discussions with these gentlemen and the documents in its possession do not, it says, support the allegation of the agreement or corrupt agreement which the state, to the contrary, contends was concluded in the encrypted facts. A related point, in Mr. Downer's affidavit, at page 152 in paragraph 49, he points out that between 2003 and 2009, when it's common cause, these three gentlemen were Thales Group employees. The group was represented by several attorneys in its dealings concerning this matter, including their current attorney of record, Mr. Dryman, as well as eminent counsel. In addition, Thales' deponent, Ms. Guerrier, who is an admitted attorney in France and a senior in-house legal counsel in the group, was closely involved in the group's response to the charges. Indeed, we've just seen in her affidavit, she said she did speak to all three of these gentlemen about this matter. We submit with Mr. Downer, it would be most surprising if Ms. Guerrier and these lawyers did not consult properly with the relevant Thales employees, take notes of what they said, and obtain and keep the documents necessary for the applicant and Tint Pty Limited to defend themselves if they were to be criminally tried in South Africa.
Aren't you back at the same position which the questions we've put to Mr. Katz is that as the trial go by, the trial court would be best suited if there is evidence before the court and they indicate that they cannot challenge it and they're hampered in their defense of the matter when that evidence is adduced.
As it pleases you, my lady, I cannot
Yes,
put better
because
than that.
we've posed those questions also to him, that those appear to be trial related and that the trial court would be in a better position to determine at each level and each stage.
I agree with that. I would simply say that this is a further reason, additional to what we've seen in this affidavit, why the court should be deeply skeptical about the submission advanced to the court on Tuesday and made in reply, to be fair to my learned friends who made it, that they do not know enough even as to whether they should plead guilty or not guilty. Lastly, in this connection with specific reference to the availability of Mr. Tetard, we're dealing with a case of delay here. So the question is, would Thales have been better off as far as he is concerned had it been tried in 2006, which was when the trial was originally scheduled to proceed against it? Now we know from the affidavits by Mr. Tetard, discussed by my learned friend this morning, that this evidence, these affidavits, which are put up by Thales itself, they are annexes to its founding papers in this case, make it plain that from as long ago as May 2004, I'm referring to the last portion of that affidavit, paragraph 8 of it, it's CG 13, at page 123, Mr. Tetard has consistently refused to return to South Africa to testify. And we see that also in CG 12 at paragraphs 47 to 49, page 117. He goes much further, of course, in his later affidavit, saying he's not willing to cooperate at all. Now, if this evidence is anything to go by, even if Thales had been tried in 2006 or 2009, Mr. Tetard would not have been willing to testify in its defense in a trial in South Africa. And returning to Her Ladyship Justice Stein's proposition, essentially and consequently what we submit is that Thales hasn't established that due to the delay, it will suffer any trial prejudice in the legally relevant sense. In other words, that the delay has inevitably and irremediably tainted the overall substantive fairness of the trial. It has not shown that there is no way in which the fairness of the trial can be sustained. The proper course, we respectfully submit, is to permit the matter to proceed to trial. If, as things turn out, due to the delay, Thales is unable to adduce evidence or to challenge some of the state's evidence at the trial, and if the trial judge finds that as a result its right to a fair trial is being infringed, the trial judge will be empowered to take the necessary remedial steps. And for these reasons, the state consequently asks that Thales' application for a permanent stay of prosecution be dismissed. My learned friend, Mr. Trengove, has indicated that he wishes to add something to my submissions.
Lord, may I ask your Lordship's indulgence for me to raise one issue which straddles the submissions of both of us, and that is the lesson to be taken from the Zana judgment, paragraph 15. Remember, in that case, the accused asked the prosecution to withdraw the charges, made representations for the withdrawal of the charges, and the prosecution agreed. 10 years later, they reinstituted the charges, and the accused then complained about the delay that was caused by the initial withdrawal. But the court then said, you can't, having asked for it today, you can't complain about the delay it caused tomorrow. In other words, remember, this is an accused who acted perfectly lawfully, perfectly honestly, exercised his rights perfectly lawfully. There was no blame to be apportioned to the accused. The accused asked for trial for the charges to be withdrawn. The prosecution were not bound to do so. They exercised a free choice to withdraw the charges. So there's absolutely no blame attached to the withdrawal of those charges. But the court said 10 years later, in the inquiry into the question whether the state has unduly delayed the prosecution, it is not open to the accused to ask for a withdrawal today and then to complain about the delay it caused later. Now, if I may call that the Zanner rule, and that is one that doesn't concern itself with blame, but simply says to an accused, if you ask for it today, you cannot complain about the delay it caused tomorrow.
Yes, because it was not an issue then.
Yeah.
Yes, that's why we're trying to find out exactly the basis on relying on
But the point I make is that it is not one dependent on blame.
Yes.
The accused exercised these rights,
Yes.
does so in good faith. The prosecution is not bound to grant it, but the court says if you ask for it today, you cannot complain about the delay it caused tomorrow. Now, if you apply that principle to this case in two instances, the first is the withdrawal, Mr. Mluka's withdrawal of the charges against Thales. Assume, contrary to all of my submissions, that there was no blame to be apportioned to Thales, that Mr. Mluka had a free choice to decide whether to accede to their request, and did so for reasons of his own. But the Zana principle, the Zana rule will still say to Thales, you cannot ask for the withdrawal today and then complain about the delay it causes tomorrow. The other situation is the one affecting Mr. Zuma, and that's this. We spoke about the litigation, firstly the warrant litigation and then the other litigation. And there is a point made, well, he was entitled within his rights to conduct that litigation. And he wasn't the only one, there were others too. But the fact of the matter is that he chose, in the exercise of his rights, to conduct that litigation, which caused a delay in the prosecution. And we would submit that the Zana rule would say, I don't care about blame, I'm not apportioning blame, but I'm saying to the litigant, You can't exercise your rights as you choose today and then complain about the delay that it has caused. So that even though you lawfully and properly exercised your rights, if it causes delay, then you can't complain about that delay. So we would submit that principle of ZANA that says you can't ask for something today and then complain about its consequences tomorrow plays a part in the assessment of both these cases. Thank you.
Isn't there's a contradiction between the ZANA rule and the NPA policy? Because it says that under B, on the restarting a prosecution, people should be able to rely on and accept decisions made by the members of the NPA. Normally, when a suspect or accused person is informed that there will not be a prosecution or that charges have been withdrawn, that should be the end of the matter.
Yes.
So how do we...
Lady, no, I submit with respect that that is quite correct, but that principle governs the decision to restart. And there has to be special reasons to restart. And it may be tested by the question whether there is special reasons. And that is a hurdle we need to overcome, and that is one we've addressed. But assuming we overcome the special reasons hurdle, the question then is it open to Mr. Zuma and to Thales to complain about the delay brought about by Thales' request that the prosecution be withdrawn and Mr. Zuma's exercise of his rights to litigate various interim issues. And we submit that that the ZANA rule says, no, you can't ask for it today and complain about it tomorrow. Thank you, Mr.
Mrs. Kat, are you ready to? Yes, thank you.
Yes, thank you.
And this being, can I borrow this? This being a reply, I know how difficult it is to listen to lawyers repeating the same facts. So I'm going to confine my reply to the areas that Mr. Trengov talked about and our responses to it, our quick responses to those. Because if I elaborate on them, I would be repeating my address on Monday. But I want to reflect this. I said on Monday that there will be, if we find any information, because we've been asking for documents, we find information. And I promised this court that by Friday, if that happens, I will address the court on that. I want the court to flag that because I'm going to use the indulgence granted to Mr. Trengov this morning to give evidence from the bar about something that was important. So I would ask for the same indulgence. It's related to Mr. Maduna and his role, but I'll come back at the end with that. Mr. Trengov says a couple of things. Most of them are incorrect in our submissions, and a couple of them are true. And I say they're true because in order to assist the court, it doesn't help to come to court to tell the court, as they do, blame everything on one person. That's basically their theory. But that's not what I'm about to say, because there are a couple of good points he made. There is one good point I want to start with that I think makes our case, maybe we overstressed it, slightly weaker. It's the part about Mr. Pikoli and the China trip. I do think Mr. Trengov is right there. I think that trip, to cite that trip as an example on its own, in my view, does not pass the test we should meet to suggest that. So on that point alone, I do agree with him. But I disagree with him on every other point he makes, except the concessions that he has made. He starts by asking this court to disregard the spy tapes. He says he's going to deal with it. He says disregard it. He then, like both of them have done with Mr. Breitenbach, they say for those periods in which we, as the NPA, were wrong, even when this morning somebody said Mr. Mshe acted without integrity. Who was the victim? Mr. Downer was the victim. Even when the NPA commits what we accept is acting without integrity as an organ of state, an accused person is to blame. And the victim is a member of that institution. There's something wrong about that belief. Mr. Trongov fudges a number of issues with hyperbole. He says, this court, yes, they concede that the decision by Mr. Nguga was wrong. And may I, to avoid any repetition, refer this court to a concession in this regard. It's on page 2712. It's paragraph 65 of their answer. I wouldn't like to read it, it's long. It's a concession. And I'm using exactly Mr. Trengov's legal principle. He directed us to Plascon events. I need say no more than the fact that the rule we are taught about in Plascon events is to determine a dispute, is to see how to resolve a dispute. I submit to this court that a number of issues I want this court to determine this matter on have no dispute, are common cause. A couple of them may have some dispute, and I think he is right that the Plascon events rule should apply there on those issues. Then Mr. Trengov continues. He says Mr. Nguga took a decision on the 23rd of August. And that decision, although wrong, we should focus on the fact that it was bona fide. Now, Mr. Nguga himself, not Mr. Trengov, he calls his own decision an anomaly. And what does Mr. Trengov do to sanitize this decision? He says it's unusual, but it's not uncommon for the type of decision. Those two words, with my little understanding of the English language, both of them mean the same thing, actually. So there is nothing in that submission. It's unusual, but it's not uncommon. Nothing there. The fact of the matter is that Mr. Nguga himself describes his action as an anomaly. I submit to this court that from that time on, whether or not Mr. Nguga's decision was bona fide or mala fide, I'm submitting to this court, you should accept the fact that it is common cause before you that it was wrong and an anomaly. And I'm submitting that on that basis alone, even if you do not have to judge his motive and how good or bad he is, on the cases, even on harams that they quote, you have to read the paragraph of harams and everybody. The problem with lawyers, we read paragraphs that we like and we don't finish them, is that these cases always leave room for circumstances in the future or circumstances that we don't know. So, maybe we blame Mr. Pikoli too much about the second period now. This is the period when Mr. Pikoli recharges. I've said that when he charges. When he charges. When he charges. That's a yeah. When he charges. We accept, and I accept that Mr. Pikoli, as he was described, is indeed a good man. I know him. And that decision on its own, when we criticize that decision, we don't criticize it because he's a bad man. He was plotting for anything. No, no, no. We say, as our cases tell us, when a prosecuting authority starts a trial, Section 35(3)(d) rights of that accused kick in. And when you do so, when you are going to ask for a postponement, it means you are not ready a couple of months later. I invite this court not to attribute that to Mr. Zuma. It's a delay that is attributable to the NPA. There is a period about the search warrants and that litigation. One issue I want to state there is that we all accept, and Mr. Trengov has accepted, that when you are exercising the right you have as an accused facing the might of an organ of state, unless you do something that is out of the ordinary, you are entitled to those, and you cannot, those decisions can be used against you. We are then told again by Mr. Trengov later in his address that the period, and this is the biggest mistake we make in analyzing, and I'm treading on thin ice here because it's about how the SCA has commented on some of the cases. This is the period of Mshe and Feather, when he then charges on the 28th of December 2007, after when he charges and then he drops them. That period, there is a theory that seems to occupy the NPA, and it's the NPA itself, that, my lord, when it's us as the NPA who've acted without integrity, and we've acted maybe unlawfully, but what we did as an organ of state, even if it's unlawful, please forgive us because Mr. Zuma benefited. It was good for him. It's patronizing, but it's wrong. It's wrong because an organ of state can't argue that please ignore even when we act without integrity. Because the decision of Mshe, even if it favors Mr. Zuma in some way, to say Mr. Zuma was the cause of that litigation up until the NAFSA decision, simply because he was a party, cannot be. I submit that it is, and I know my learned friends know this, it is utterly opportunistic to blame an accused citizen for a decision in which a political party that has become interested in a matter fights with an organ of state. And you say that accused, because he was part of that litigation, is primarily to blame. Or if he is not, I think Mr. Trengov uses the word, they are co-responsible. An organ of state that could have pursued its decision. And Mr. Breitenbach attempts to answer it later. He says, yeah, let me see these exact words. He says, even if the NPA had not opposed the DA, given Zuma's style. Now, my lord and my ladies, there's a danger here of what I call a convenient mythology, a theory that is created without evidence. You are told to believe the grand narrative we've been fed with for a long time, the Stalingrad. You are not given evidence. It's accepted. You must know that it's Mr. Zuma's style. No one gives you evidence. What is this style? Oh, we are told Mr. Kemp once mentioned it. Just because Mr. Kemp maybe elegantly describes litigation between parties, it's evidence of Mr. Zuma's personality and how he approaches court. I submit that theory is wrong. I submit that this court cannot say that that period, which in our view was between a political party primarily and the NPA, and the actions of Mr. Mshe cannot be attributed to Mr. Zuma simply because we believe, it's another grand theory. When Mr. Mshe did this decision, he did it because he is a Zumite. That's not evidence, it's speculation. I submit that he can't be blamed for that. And there is no evidence in our submission that it is the case. We are then told that Harams has already told us that motive does not matter. This is to deal with the case we made about the political meddling. And I want to introduce a conceptual difference here, because our learned friends keep dragging the concept to motive because they want to seek refuge in Harams. There's a conceptual difference. And they drag it to the side of this concept which says motive, because Harams has said something about motive, and they think it covers, once you are covered by Harams, it means your activities, no matter how unconstitutional, were covered by that statement by Harams. It is a misreading of Harams, it's deliberate, and it's not what Judge Harams was saying. He could never have meant that I can act unconstitutionally in pursuit of an accused as an organ of state. It does not matter. He was dealing with a different question, and I'm submitting that conceptually those two are different from an organ of state. That does what I read to this court and submitted, that I submit and invite this court to draw an inference that if you look at that decision, you look at what was discussed between the two people. I said they started together and they ended together. And Mr. Harams, in the very paragraph that is relied upon, right at the end of that paragraph, right at the end, he makes a telling point. He makes a telling point. He says, he tells us that he does not have. Can I read this? Is this one? But anyway, he says at the end, he leaves room for the fact that nothing was before him that suggested that there was something wrong, there was meddling.
Mr. Tikakane, are you referring to paragraph 37 of the Harams judgment? Because that is where the court dealt with the motive behind prosecution is irrelevant, and that is where he deals with the political considerations before him. And it ends off with the same, in that paragraph, because that's where he deals with motive being irrelevant.
Yes.
Yeah.
No, I'm dealing with a different paragraph. But even if that was the case, I'm not dealing with that paragraph now. It's a paragraph, my junior will find it now. But at the end, my juniors are a little slow today.
I'm using the old system
The old
by just
system.
having the
But
real pages.
let me indicate the point, because I made it on Monday, and
Yes.
if I'm wrong, the case will tell you, is that he did not have before him the evidence that would really have made it correct for him to make a ruling that there was meddling. And he was right, there wasn't. But what I submitted to you, to this court on Monday, in my submission, fills that gap that was there at the time Harams was there. And I invite this court to consider what eventually happened. I could read, and I invite the courts to read more what I couldn't read in those spy tapes. Then Mr. Trengov also says that it's a point I didn't want to make because it sounds like lawyers complaining about fees. He says you should know how much this has cost taxpayers' money. You just have to count how many people are on my right to know how disingenuous that can be. Because we have asked, we say if you ask in courts to balance truly and fairly how this litigation has been pursued and pursuing what, you've got to look at all of those costs. And we've said to them, give us your costs, what it costs the state to bring 9 people, others salaried, others private, and pursue a man who at the time, the state is squeezing him out not to be able to afford lawyers. As we speak, we say, now that they've raised it, we've asked for it, they refuse because they want you to strike a balance between factors that they choose. Mr. Zuma remains here, squeezed out of everything he could do to pay anybody. That's why he ends up with this. It's because he has no finances. The state has squeezed that for him. And I say they must give us the information if they want the court to analyze how much it has cost. Lastly, before I come to what I said I'm going to read to this court, because it's a document, I'm relying on what I promised this court on Monday and the fact that Mr. Trengov was allowed to give evidence from the bar. The last point I make is this. I invite that the court look at the evidence we presented about political meddling that is obvious when balancing the correct position Mr. Trengov puts to you. He says society has so much trouble. There is corruption. The nature of the crime is important for you to balance, and balance it with this broad term now called the justice, the interest of justice and the public. It's usually used by lawyers and journalists when they want anything they want. It says, balance those. I am adding a factor that I agree with him, you must balance it, and maybe I do not know the answer. But I want you to add these 2 factors in that balance, because all of the cases we quote, Zana, Sanderson, Bothma, and all of them, the ones, some quotes we ignore to say to you that the courts do say, and that's the conceptual point I was making, when you are a primary cause of the delay, and the word is primary, and it's important when you decide on this period for which Mr. Zuma is blamed from Share's lack of integrity and decisions that were wrong. And we are told that the reason for that is that Mr. Kemp considered that once the section that was used was wrong. I would have considered too, if I have to be honest with the court, because it's a wrong legal issue. That's what lawyers do. But to blame Mr. Zuma simply because his lawyers did the right thing, to agree that they had messed up, and that they had received legal advice wherever they get it, they say they get it from skilled people. They used the wrong section for 9 years. All of them, paid by the state. That's what they did, but we must blame Mr. Zuma. I ask this court that it must put in all of those balancing factors the presumption of innocence, whether it's not compromised when you delay like that. I submitted the facts on Monday on which I rely to say the political meddling was obvious. This morning, Mr. Trengov told this court, and he says this on behalf of the NPA, about Mr. Maduna. Mr. Maduna's role, although he was answering the case of Thales, Mr. Maduna's role was minimal, really. It was to that meeting. I'm gonna read a letter. We asked them about it yesterday. They are going to object right now. But I asked, we sent, my attorney has come to know of a letter. And I promised on Monday that if we do, because we keep asking for documents and we are not told, I said if we do come into contact with a document, we will tell this court what that document is, but we did more than that, because it's their document. It's not ours, it's theirs. We asked them yesterday, do you know of this document? My attorney tells me, of a document like this, please give it to us. Well, I don't want to defy the court, but the point I'm making, because I want the court to guide me on this, is that the document I'm about to read will tell you that in March 2018, this NPA that tells you that the role of Maduna was limited to that meeting. In 2018, it was still checking facts about that and asking about an investigation into his involvement and bribes and the involvement of Thabo Mbeki in a letter that I want to give to this court on that promise. If Mr. Trengov could tell us that an unknown source told his secretary that someone is dead, I want to be allowed to read this letter to the court.
Fresh evidence. If my learned friend wants to adduce new evidence, fresh evidence, additional evidence, after close of pleadings, in reply, then they must bring an application and motivate us. And we'll consider it when they do. Yes?
I don't really think that, because that's information we wanted about a witness.
And
Yes,
let me just say,
yes.
he's wrong to say that I told the court anything
Yes.
about Mr. Maduna's role.
Yes.
I read from the
From the
affidavit before the
affidavit,
court.
yes.
I didn't elaborate on it at all.
And about the witness, we asked for the information.
And about the witness, let me say this. I said before to you she was alive and well and living in Pretoria because that was my understanding of my
Yes.
facts. I then learned that that statement was no longer true. And I made a concession to Thales, which is to the disadvantage of the prosecution and for the advantage of Thales. It was a concession made to them. But the court is welcome to disregard it. It would be to my benefit if the court were to disregard it. It would be to Thales' disadvantage. But I did not intend to, did not in fact introduce any fresh evidence. If my learned friend wants to introduce fresh evidence, then he must bring an application for us to consider it.
Yeah, maybe we should go out quickly.
Can you just take 5 minutes, like, just outside and deal with this?
Just imagine. We know this case is going to tell us the stand of our position in this country. It's a vital case. We must take everything to stand for judiciary. No, they know that for the mileage to deal to this thing. No, now we must sort out. Besela ngosiphe kuseni. Edelela le nkulumo yangani.
see, Mrs. Kakani, sorry, we see it's 4 o'clock. I think we have discussed the matter. It will be better if perhaps the two of you can, see whether you can't find each other. If you can't, then we'll have to bring an substantive application. Can we stand the matter down until tomorrow, if possible? Can we start at 9 tomorrow, if we can?
I'm in the court's hands.
Is everybody happy if we start at 9 o'clock tomorrow?
As the court please.
Please, we stand the matter down and start at 9 o'clock tomorrow. Please reflect on the matter, on the issue of, and then please come back to us and tell us what you have decided.
Okay, we stand adjourned until 9.
9 o'clock. Thank you, Court Regina.
Object.